Hey, everybody, and welcome to Thursday night. Hey, everybody, John Skiba here from the Consumer Warrior YouTube channel. It's Thursday night. It's 5:15 p.m. Arizona time, and so we're here. We're doing the live stream we do each and every week. Again, my name is John Skiba. I am a consumer and bankruptcy attorney in the state of Arizona and founder of the Consumer Warrior YouTube channel and Consumer Warrior University, which it provides templates, tutorials, resources for people who are dealing with serious debt problems and really not sure where to go. I started all of this years ago. I've been practicing law for 20 years, but I started the Consumer Warrior type things as well as the YouTube channel because I ran into so many people that were in a situation where they're getting sued particularly by junk debt buyers. They didn't know what to do, and they ended up with these really horrible wage garnishments, bank levies, all that, when if they push back just a bit, I often found that there were things they could do to make their situation quite a bit better. So while I am a licensed attorney in the state of Arizona, I'm not licensed anywhere else. So you should not consider this to be legal advice. This is just some guy just chatting on YouTube. So take that for what it's worth. If you need legal advice and you're in the state of Arizona, you'll see my telephone number and our website scrolling across the bottom of the screen here. There's also a link to my website down in the notes, at least after we publish this, there will be. And but if you're in another state, finding an attorney in your particular location, most attorneys do free consultations and can at least give you some guidance as far as which way to go. So the way that we do this is if you, I know this is being broadcast on Facebook and Twitter and LinkedIn, but on the YouTube channel, there's a chat section. If you have a question you want me to go over and have a discussion on, you can go there and put your question in that chat section. I'm going to put it up here on the screen and we're going to go over it. And maybe I can point you some directions, give you some resources as far as which way to go. Let's start off with Smooth Landing, who is here nice and early tonight. Good evening. It says, I've been trying to settle my lawsuit with the original creditor, Truist, and every time I offer, I get pushback asking for hardship documents like pay stubs, W-2s, bank statements. I do not feel comfortable providing those. Should I try and reach out to Truist directly to settle instead of the law firm? Currently have a bench trial set for October and motion of no evidence. Judgment was not or will not be signed by the judge. So a couple issues and good questions here, Smooth Landing, as far as one question you had here was whether you should reach out to the original creditor, Truist, rather than dealing with their lawyers. And I hear this a lot, particularly if a junk debt buyer is involved. People are like, I don't want to deal with the junk debt buyer. I don't want to deal with their attorneys. I'll just reach out to the original creditor and see if we can negotiate it. Unfortunately, that won't work. In a situation like this where the original creditor filed the lawsuit and they've hired lawyers, they're just going to direct you back to go through their lawyers. They're not going to deal with you directly. They're not going to do it. And not only that, if it's a junk debt buyer, they're alleging, again, that they purchased the debt. And so if you reach out to the original creditor, they'll likely just say, we can't deal with you either. So unfortunately, you're going to be dealing with the law firms. The law firms are often taking their instructions from their clients, because I see this. We negotiate here at my office here in Arizona. We negotiate with different creditors, but the same law firm often. One law firm will represent 10 different creditors. And I noticed that not all creditors require the kind of documentation that you're providing. I agree with you. I am always hesitant to offer or provide any type of financial documentation because, it's kind of this catch-22 that they're saying, hey, we're not even going to consider your settlement offer until you provide us with the documentation that we want to see, your finances. And then if you provide it and they say no, then you've just given them a roadmap to all of your assets. And so it's one of these things where there are certain things you can press back on. Maybe you can provide affidavits. They're probably going to require some financial information, particularly an original creditor, that helps them to know whether they should be settling the case or not. But there's a lot of risk involved there. And so that's what you're going to have to weigh is, whether if their case is strong and you're in court and you don't think you're going to win, it may be worth it to be able to provide the documentation, particularly if it does show hardship. If it's something where there's medical issues, if there's job loss, if you don't have any real estate, those types of things are the things that can help you to get some kind of settlement in place. All right, let's see what Monterey MX say. What's the lowest settlement that I've seen from Bank of America just before jury selection? Their attorney offered 50% payable in 21 days. I took it and sent them a cashier's check for $5,000 and some change. Original creditor lawsuit. So Bank of America is one that they often don't sell their debt to junk debt buyers. They often bring the case themselves. It's impressive. You're all the way there for a jury trial. Something I'm sure that the other attorney did not want to do, even if their case was strong. That's not something they wanted to go through. And if you're already at jury selection, they've already put a ton of work into it. So if they were willing to do a 50% settlement, that's not a bad settlement offer. Original creditors, it's usually going to be at least 50%. American Express, they often bring their own lawsuits. Sometimes Discover does, and they're going to want somewhere between usually 70% plus when it comes to settlement, just because they know they have the documents, the evidence. Situation like this is probably not too bad as well. Like in Arizona, if you would have taken this to a jury trial and you would have lost, they could have gone after you for attorney's fees. So if your debt was 10 grand and they settled for 5, it's probably not a bad deal, because if you would have went and lost against the original creditor, you could have ended up with a $50,000 judgment easy in Arizona, at least. That's how it would have played out. So I think you did yourself a good deal there. I wouldn't have any problems at all with a 50% offer in a situation like that. So Randall said, thank you about the consent judgments. Thank you. Appreciate all you do for the channel, all you do to support the t-shirts that you sent my family. My kids are rocking these law t-shirts all the time now with the Lady Justice, Scales of Justice. It's awesome. Thank you for that. All right. Leslie says, should I start my rebuilding until my Chapter 7 discharge? I'm assuming you're talking about rebuilding your credit until your Chapter 7 is discharged. You can always start the habits and things like that. They're going to start to rebuild it. And if there's, contracts and agreements or credit cards that you enter into after a Chapter 7 bankruptcy is filed with the court, even if it hasn't been discharged, those things will show up on your credit. I'd be really careful. So what you'll see if you file a Chapter 7 bankruptcy, almost immediately your mailbox just gets blown up with credit card applications, car loan applications. And the reason why clients always tell me, I'm shocked. I thought that when I filed bankruptcy, I would never be able to get a loan again, a credit card again. The reason why they're sending that to you is because they view you as a good credit risk. And here's why. One, they're assuming your Chapter 7 is going to eliminate all your debts, or at least most of your debts. And you're going to have a lot more disposable income to be able to spend on their new credit card. Two, again, like I was saying, if loans and credit cards, contracts you enter into after your Chapter 7 bankruptcy is filed are non-dischargeable. They don't, or at least they're not dischargeable in your current bankruptcy, and you can't file a new bankruptcy now for another 8 years. So they kind of got you. So the interest rates are not going to be good early on. The car loans are surprisingly, they're not horrible. They're usually around 9 to 10%, but they're not great either. And credit cards are going to be high interest rates early on. So you got to be really careful with that. Once the discharge order is entered in your Chapter 7 bankruptcy, I usually tell my clients to wait 30 to 60 days, 1 to 2 reporting cycles for the credit reporting agencies. What your credit report will look like is all of your creditors will still be there, but the debts are going to be zeroed out. And then there may be a notation that it was discharged in bankruptcy. It usually takes about 18 to 24 months for your credit to fully recover. FHA, VA, they'll do mortgage loans 2 years after a Chapter 7. Other lenders are 3. So to answer your question, that's my long-winded answer. Yes, it's fine to start trying to rebuild that. I would just be careful about incurring any new debts or getting into a bad credit card situation even before your current Chapter 7 is discharged. So, all right, let's see here. AJ was saying, why should I keep paying my credit card if the credit card company filed for Chapter 11? So good question. So if you have a credit card company, they file for bankruptcy, do you have to continue to pay them? We ran into this situation a number of years ago with one of the junk debt buyers, Cash LLC, CACH LLC. Junk debt buyer, they filed for bankruptcy protection. So they're out here buying debt, suing people, and then they file for bankruptcy. And then what happened is they got picked up by another company, Resurgent Capital, who bought them out of bankruptcy. So the reason why you have to continue to pay your credit card debt is because them filing bankruptcy in and of itself does not eliminate the contractual relationship between you and the entity that's in bankruptcy. And Chapter 11 is a reorganization. It's a restructuring of their company. So they intend, at least most people that file chapter, most entities that file Chapter 11, they intend to come out of that and continue to still do business. So if you stop paying on your credit card, even though the lender is in bankruptcy, it's still going to have a negative impact on you, and unfortunately doesn't eliminate your liability there. So, all right. ALK, can I take a minute and explain car reaffirmation? I'm worried something will go wrong during this process, and then my lender will stop accepting payments. Let's see here. So the only thing stopping me from starting the Chapter 7 process is losing my vehicle. I want to continue to make payments on time for the full term. Car falls under the New York exemption plus the wild card. All right. I'm taking a deep breath because the reaffirmation process in a bankruptcy case is kind of a mess, in my opinion. So the bankruptcy code was revised back in 2005. I remember when I was in law school. I was in law school from 2000 to 2003. My bankruptcy professor was part of the group of people that were revising the bankruptcy code. And finally, they got it done. Congress passed it. It's a new law. The bankruptcy code's in 2005. One of the changes is they added this term for reaffirming car loans. And what it says in the bankruptcy code is that if you have a car loan and you want to keep that car, you need to sign a reaffirmation agreement and submit it to the court for approval. And what the reaffirmation agreement is, it's essentially a new contract that you're signing after your bankruptcy case is filed. It's meaning that it's not going to go away. The debt's not going to go away in your bankruptcy because it's a post-bankruptcy filing contract. Essentially, you're reaffirming the terms of the original contract with your car lender. It also says if you don't reaffirm it, that the lender has the option, the bank has the option of taking the car back, of repossessing it. Now, early on, like 2005 to 2008, you saw some lenders who were doing that. If you didn't sign the reaffirmation agreement, they were repossessing it. The most notorious was Ford Motor Credit. They were repossessing cars even when people are completely current on their payments. But the banks and the lenders learned relatively quickly that why are we doing this? Why are we repossessing vehicles where the people are completely current on their monthly payments? Even a reaffirmation, no reaffirmation. And so what I have found, and this is particularly true in Arizona, two things. One, if you're continuing to make your payments on your car, the likelihood of it being repossessed are very small. So that's the first thing you need to do, is make sure you're continuing to make your car payment. And while your bankruptcy is active, they may not give you online access. You may have to actually mail it in or go to the branch and make it. It's annoying and inconvenient, but you can still make your payment while it's going. So it's important to continue to make that payment on your vehicle. But the reaffirmation agreement, let me tell you what happens in Arizona. And this is, I think, very Arizona specific, but there may be something similar. So if, like in New York, you ought to talk to a bankruptcy attorney. There's kind of three parts to a reaffirmation agreement. You have to sign it. It's an agreement that the creditor, you sign it, your attorney signs it, the creditor has to sign it, and then it has to be submitted to the judge for the judge to approve the reaffirmation. In Arizona, the bankruptcy judges are not big fans of approving reaffirmation agreements. The reason why is if the judge signs off on the reaffirmation agreement, then you are bound by the terms of it. And let's say something happens unforeseen. A year down the road, you have a medical issue, the car gets in an accident, whatever. The creditor can then come after you and sue you for the balance. Now, if the court does not reaffirm approve the reaffirmation agreement, then the creditor is not able to come after you for the balance. That technically that balance was discharged in your bankruptcy. So there's some benefit and some protections if the court doesn't approve it. So in Arizona, at least, most of the judges will just say, I'm not going to approve this. Just continue to make your payments and pay your car off and kind of go your way. The only drawback to that is if there is not an approved reaffirmation agreement in bankruptcy, the lender does not have to report any information to the credit reporting agencies. So they don't report anything good or bad to your credit. And a lot of people are concerned that they're not going to get the bump for their credit score that they're wanting from that. We had a judge here in Arizona actually bring in various executives from different lenders, from car lenders, as well as from the credit reporting agencies like Experian, TransUnion, Equifax. And they all testified that the increase in the bump you would get in your credit score after a bankruptcy from a car loan like that was minimal at best. And so that really played into why the judges in Arizona don't approve them. So that's long story. It's not short. That was just a long story about reaffirmation. I highly recommend you talk to an attorney, but I can tell you in general, if you keep those payments current, you're going to be fine. So, all right, let's talk to Crazy House Saloon here. I'm in the process of answering for the initial citation from PRA, Portfolio Recovery Associates. They are not using my current legal last name, and I want to incorporate the most recent court docs against them, but not sure how. So the first issue, and I see this quite a bit, where someone's using like a maiden name, or the creditor is, and you've remarried, the name is changed, or for whatever reason the name is changed. That is a procedural defect the court's going to allow them to remedy. So that alone will not get you that far. So they're going to be able to fix that eventually. They could even fix that after judgment was entered. So that's not going to be a thing that's too big of a deal. As far as the most recent court doc, so I released a video, I think we just released it this week, about the portfolio recovery, the order from the Consumer Financial Protection Bureau. They came in and sanctioned them. So how you use that, go back and watch that video. I just released it. I think it was literally yesterday we published it. I actually go through the order and show what kinds of things you need to do. How it's beneficial is if you're in trial and going against them, or if they file a motion for summary judgment, because summary judgment is them just providing these documents to the judge and saying, just look at this and tell us if we win. You can go in and say, Judge, basically nothing they're saying is true. These are not accurate. And the reason why we know that is, look at this. Here's this order from just 2 weeks ago where they stipulated to it, where they were providing documentation and information that just wasn't accurate. But I would recommend go back and watch that video. It's a little bit longer video. I kind of do a deep dive in there, and I would go take a look at that. So Al, thank you for supporting the channel each and every week. Sincerely, I appreciate it. All right, let's see here what Dan has to say. If I discharge an auto loan balance in Chapter 7, do not reaffirm the loan, but keep making monthly payments, do I need full coverage for that vehicle? Dan, that's an interesting question. That is something I truthfully I've never had that question. You did it. Maybe you stumped me here, because I see what you're saying. Because if a loan is not reaffirmed, kind of this whole thing I just talked about, if a car loan is not reaffirmed in a Chapter 7 bankruptcy, what you'll see on your credit report, you'll see that there's a zero balance that's owed on it. And so I guess the question would be that the full coverage, you're having full coverage car insurance on it. In the event that it gets in a car wreck, then it pays off the note. So, the benefit of the full coverage is also that you would get money to buy a replacement vehicle. But if you got in an accident and there was a reaffirmed and there was no reaffirmation agreement approved by the court, and you had full coverage on it, then no money's going to go to that lender. So I guess that's the only reason why I guess you could keep full coverage. I'll have to think about that. It's actually a very interesting question. I haven't had that come up, where if there's no reaffirmed loan, why do they need to? Well, I'm thinking out loud. This is true live stream, because I'm thinking here's the only other thing that would make me think twice about that. The debt is eliminated. So there's two parts to a loan. There's the promissory note that the car lender has, but then there's the lien that they've attached to your vehicle. So technically, the debt under the promissory note is discharged. However, the question is, do they still have lien rights against your vehicle where if you got in an accident, you need to pay that off. I'm gonna punt. I know that's really unsatisfying. I'm gonna punt but that is a great question. And I'll look that up. And maybe next Thursday we can go over that. So come back next Thursday. But I'll look into that and see if there's any case law on that specifically. My guess is that because they still have lien rights, that you'd want to maintain full coverage insurance on it. And the reason why, because they may be able to receive some type of payment, even if it's not approved. But I'll look into that. But that's that's like a law school type test question that they would go into and have you analyze. So good question. I will check that out. Monterey says, now on to LVNV. 2 different attorneys filed at both my old and new address. The old address is in a very left-leaning Democrat area. The left-leaning judge approved my demanding discovery request. The right-leaning judge whittled down my discovery request considerably. In Texas, discovery requests must be pre-approved by the judge. I've seen that. It's interesting. So he says, was answering the unserved lawsuit in the left-leaning area a good idea? Well, I think it's always good to answer. I always say my recommendation is always to deal with these things head on. I don't ever recommend dodging service. I don't recommend. I think it's better to just deal with it head on, because there are defenses like we brought up. So, but you bring up a point that's interesting. Judges, they all have their own backgrounds. They have their own biases on, and that's why I always say here in the justice courts in particular, in Arizona, where there's a couple dozen justices of the peace, most of them are not attorneys. It's kind of the wild, wild west. I mean, you see different things, and so it's fairly unpredictable. Our superior court judges, it's a little more predictable, but even then, certain judges have certain ways that they tend to look at these kind of cases. So interesting issue there as well. Kevin says, in Arizona, if I'm able to settle before 20 days, do I still have to file an answer? Good question. I get this one frequently. If you settle and you get something in writing and you make the payment and it's done, then the plaintiff will go in and they'll just voluntarily dismiss the case. Now, Arizona is unique in the way that a default judgment is entered. And the reason why this is important, because my answer in general is yes. If you settle this, you don't need to file an answer, because in Arizona, you have 20 days to file a written answer with the court from the day that you get served with a complaint and summons. And if you don't file an answer, then a couple of days later, you're going to see that the creditor, the plaintiff, is going to go down to the court. They're going to file a document called an application for entry of default, and they're going to mail that to you. And from the day that they mail that to you, you are then given 10 additional business days to file an answer with the court. This is the law's way of saying, are you sure you don't want to file an answer to this complaint? And to make it more confusing, so the first 20 days are just straight calendar days. They include weekends. But the 10 business days from the date that they mail the application for entry of default, they don't include weekends. It's just 10 business days. And so if you settled the debt and you've sent in you signed the agreement, they've sent you a letter, you sent in the payment, and then all of a sudden you get an application for entry of default in the mail, that triggers to you, hey, I've got 10 days to file an answer, and something's not connecting with the plaintiff. That would give you time to reach out to the plaintiff, see if they can get the case, if they'll go ahead and because they can just voluntarily dismiss with prejudice at that point. But if they're ignoring you or whatever, there's kind of this grace period for you to go ahead and file an answer. That's a very Arizona specific thing. In many states, you have 20 days, 30 days. If you miss it by 1 day, it's default. So be careful there. So, all right, let's see what Kamal says. Says, would you please explain about the debt civil lawsuit concerning the contempt of court actions if a debtor fails to show up on the date of court? Would the debtor be arrested in the future? So, a lot of times people ask me, if I don't pay my credit card debt, am I going to be arrested? Am I going to go to jail? And I say no. For not paying a credit card debt, for not paying your medical bills, there's no debtors' prisons. Those were abolished in the early 1800s in the United States. You're not going to jail for not paying your debts. However, here's the little asterisk here, is that there are certain proceedings if the court subpoenas you to come to court or orders you to come to court. So if a judgment's been entered against you, for instance, Like in Arizona, they can do what's called a judgment debtor's examination. They can require you to appear either at the courthouse or at the creditor's attorney's office and answer questions about your assets, and so that they can try to collect the judgment. And if you do not appear at the judgment debtor's exam, you've then ignored a court order for you to appear, and the court could hold you in contempt, and they can issue a civil arrest warrant. In Arizona, they will issue civil arrest warrants if there's a order requiring you to appear or a subpoena or something like that. If you don't show up, the creditor can ask for a civil arrest warrant. Now, does that mean that the police are going to come kick your door down tonight and drag you into jail? No. But if you get pulled over for speeding, if you get pulled over for running a stop sign or whatever, absolutely. The police are going to take you into custody, put you in jail. So if you receive a court order that you need to appear somewhere, you need to appear. That's different than if, the court sets like a pretrial conference or a status conference, and you should go to that as well, because your case will probably you'll lose your case if you don't show up, but you're not going to get an arrest warrant or a contempt order for something like that. Whereas if the court actually sends you an order, and usually you'll know the difference if it's a subpoena or if it's an actual order. I mean, it'll say on there's usually warnings from the court saying, you better pay attention to this one, because there's going to be some consequences if you don't show up. So, all right, let's see here. Dan says, can you dispute with the credit bureaus for the payments not being reported in the credit bureaus? So Dan had a good question earlier about insurance on a reaffirmation agreement. If there's not an approved reaffirmation agreement in the Chapter 7 bankruptcy, again, your creditors, the lender will not be reporting information. And this is kind of a workaround. So Dan, as far as the way that you can do this, I have seen this work. I've also seen it not work, but I've seen it work where you can dispute, like, let's say you're making the payment, you're paying it online, or you're sending in a check, or you have a receipt, where you can dispute through the credit reporting agencies saying, look, I've made all these payments, they're not reporting anything. Once you dispute it through the credit reporting agency, and you need to include proof, like documented proof, like your receipts, canceled checks, all that, they have to reach out to the lender. The lender has 30 days to respond to it. And if they do that, if they don't do that, then they'll update it. But if they're going to have to respond truthfully saying, yeah, we received the payment. So I have seen that work. The problem with it is it's a lot of work. I mean, because you're going to have to do that. You could do it each and every month. I've had clients who do it once a year. They'll submit all the proof of payment to have that updated on their credit report. And like I said, when the judge had all those people that came in, they were able to show with pretty competent evidence that there wasn't a huge bump with those payments. So, all right, let's see here. See what Randman has to say. Would you possibly know why I haven't heard anything back from the lawyer suing me over credit card debt? I filed my answer and filed the next part. The answer, it's been a couple months. I always say that the wheels of justice, particularly civil justice, move very slowly. Also, a debt collection firm, they usually have minimal attorneys and thousands of cases. And so it could be that, if it's something where you don't hear from them for a long time and there's no hearings or something like that, eventually I have filed motions to dismiss for failure to prosecute the case. They're the plaintiff. It's their job to push the case along. You may want to check the rules of civil procedure, contact the clerk of the court, just make sure there's nothing that hasn't been filed, and see how long, if there's any upcoming deadlines, status conferences. And if not, just hang tight. Like I said, it's their case. You can file a motion to dismiss for failure to be able to push that thing forward. So, all right, let's see here. Let's say hi to Muriel. It's good to see you. And Rennie's dealing with the wild, wild west. Absolutely. So let's see. One Tough Cookie says, is settling in $2,400 Capital One 2-year-old credit card debt for $800 a good deal? Yes, it is. You're dealing with an original credit. If you're dealing with Capital One directly, it's original creditor. You're getting a third of a settlement there. That's absolutely that's not a bad deal at all. So, yep, Monterey agreeing with me. Take it. I'm agreement. Take it. So, Let's hear about the Wild West. I have a lawsuit in the Justice Court. Basically, every motion I made has been denied except Gerstel Law was denied. Trial by telephone, so they have to show up. I can't get any information on instructions for prepping my evidence, exhibits for trial. Their witness is allowed to testify by phone. Unfortunately, that's fairly that's fairly common now. I used to object to telephonic witnesses, and then COVID-19 came along, and basically the whole world went. I rarely go to court. I think I've done live streams the last 2 times I've been to court in the last 3.5 years. And so the courts are just, they have the technology in there now, and they're allowing telephonic witnesses. So keep on pressing the issue. Rini, go check my Consumer Warrior University. The link's here in YouTube. I have a whole tutorial on how to prepare for trial and how to present to trial. Go step by step through the whole thing. It'll show you how to get that done. So, all right, let's see here. Justin, thank you. Real deal. I try. Appreciate that. Rainey, let's see. Hope that they don't show up. If they don't, will the judge grant a continuance? I litigate against Gerstel a lot, as in pretty much every working day of my life. They'll show up. I would be shocked if they didn't show up. I haven't had an attorney not show up for a hearing in probably 10 years, at least in Arizona. I think they'll be there because if they didn't. So I can tell you this, I have done this. The last time an attorney didn't show up, the judge is like, well, we'll continue this out. And I was like, if I wasn't here, my client wasn't here, a judgment would have been entered. And the judge had to agree with that because they would have granted judgment immediately. So you need to object to that. So, all right. Joe Navarro says, what happens if one can't continue to pay a Chapter 13 monthly payment due to changes in employment? So there's a couple things you can do. This is a little bit, bankruptcy is federal law, but it's a little bit state specific depending on, as far as what the trustees will allow you to do, the Chapter 13 trustees. In Arizona, we can file an amended plan and seek a moratorium of plan payments for a short period of time. So recently I had a client who lost a job. We filed an amended plan seeking 90 days of no payments so they could go out and get new employment. Now, in a situation, if let's say you don't get a new job, or let's say your job goes down considerably, like the income, Chapter 13 is a fluid process for the entire 3 to 5 years that the case is active. And you may need to file an amended plan to either increase or decrease your plan payment. Or if you just can't afford it anymore and then you do qualify for a 7, it's even possible in certain situations to convert your case to a Chapter 7. So there. All right. Let's see here. If we have a couple more, kind of going a little bit long tonight. Let's see. Rainey, I'll go in the community and I'll do that. And you know what? I know you're a member of the community already. I will send you a link to the video you need to watch, because I know if you're a member of the Consumer Warrior University, you have access to all of my tutorials. So Rini, I'll go in there and do that tonight. Let's see here, a couple more. We have lots of good comments, lots of good questions tonight. So, all right. I think maybe we'll just call that good for tonight. There's a lot in there, and we're going a little bit long, so I like to keep these videos about 30 minutes. So, but yeah, if there's deep dive questions or templates, go check out the Consumer Warrior University over at YouTube. There's a link. I'll put a link down below as well, and there's a bunch of information there, tutorials, and also, like I told Rini here, I will go in and there's other people that are providing information, but I also provide some tips and kind of point you in the right direction to some different strategies on how to deal with that. So, well, hey, everybody, thanks for checking in tonight. Thanks for all the great questions. Thanks, Dan. Man, gosh, we got some questions that have got me puzzled here that I'm going to have to go back and do a little legal research, and we'll come back next Thursday night and do it one more time. Thanks for watching tonight.